guys.
We may as well have Bill come sit here too.
No, keep him in the office. Keep him in. He's a litigant. He can't be here.
All right.
You want to keep him there.
All right, it's okay.
It's okay. That's all right. Otherwise, the stack will be dead. Yes. As they say.
I think so. Okay. I have so much stuff to catch up on at the house. All right, I think we're ready.
Good evening. I'd like to call this meeting to order. Today is May 14, 2018, 7 o'clock p.m. Adequate notice of this meeting has been provided by a posting on the bulletin board in Village Hall, by mail to the Ridgewood News, the Record, and by submission to all persons entitled to same as provided by law of a schedule including the date and time of this meeting. Roll call.
Councilman Hache is not present this evening. Councilman Seaton?
Here.
Councilman Voigt?
Here.
Councilwoman Walsh is not present this evening, and Mayor Newton.
Here. Please stand for the flag salute.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please join us in a moment of silence for our men and women serving our nation, our first responders, and all those who are victims of senseless violence. Thank you. So as we begin this meeting this evening, if you're here to make comment on the public hearing for the water rate ordinances, please hold your comments until the public hearing so you're on the record with your comments during that public hearing. So we're going to start with regular public comment, which is 3 minutes per person for a total of 40 minutes. But again, if you're here to speak during the public hearing, we want to make certain that your comments are recorded in the public record for that public hearing. So with that, public comment, 3 minutes per person, 40 minutes. With that, we'll close public comment and move on. Just for the record, anybody who's interested in speaking, did everyone sign on the sign-in sheet? Is there anyone who hadn't signed, did not sign? Okay, we're all good. Very good. Okay. I move the clerk, so now we're just going to the continued public hearing. I move the clerk read ordinance 3636 by title on the fourth reading of the public hearing thereon be open.
I have a second.
Second.
Seaton,
Yes.
Voigt,
Yes.
and Newton.
Yes. Will the clerk please read the title of ordinance 3636?
An ordinance of the Village of Ridgewood in the County of Bergen, New Jersey, amending Chapter 269 of the Ridgewood Village Code, Water, and Code Chapter 145 Fees to reestablish the water rates and fees for the 2010 through 2017 calendar years.
The hearing on ordinance 3636 was continued to this evening's meeting due to the fact the Village Council wanted to allow additional time for the public to ask questions and make comments about the water rate study as prepared by Howard Woods. Each speaker will be limited to 5 minutes, and the public hearing is now continued. What we're going to do is call individuals up. The Deputy Mayor is going to call in order of as signed in on the list.
Oh, you have two. Oh, never mind. Mark Bronius.
So, Mark, before you begin, I know there are some individuals that are here representing that they'll be speaking for other individuals, so if you're speaking just for yourself or you're speaking on behalf of somebody, just please put that on the record. Thank you.
Please identify yourself.
Mark, you want to just move that microphone to the center so we pick up everything you say. And everyone back there can hear okay? Great, perfect, we're good. I know. We can hear you from all the way from Midland Park, really.
Is the green button on? Is the green light on? Okay.
Now it is.
Okay, there you go.
Now
See, I didn't even need this.
Now we really can hear you.
Yeah, before I start, I feel it's very important to recap how we got here. 2011, a lawsuit was filed to vacate Ordinance 3236, which was a 21% rate increase, 3272, which is a 5% rate increase, 3319, another 5% rate increase of a total of 31%. This litigation has not only been lengthy and time-consuming, but very expensive to all of our taxpayers. When you read Judge Lisa Perez Fisher's order for judgment, opinion, and legal conclusion, as I'm sure you all have, and know the importance of this issue, you should be able to conclude that every stone was overturned and much thought was given to her judgment. To address Ordinance 3636 point by point and separate some facts from fiction, I don't want to debate Judge Fisher's opinions, because just like you, I agree with some, disagree with others, and our judgment and rulings as of now stand. When Judge Fisher made her initial ruling, and it states, the judgment is entered in favor of the plaintiff, Township of Wyckoff, Borough of Glen Rock, Borough of Midland Park, invalidating the Village of Ridgewood's ordinance number 3236, 3272, and 3319, as adoption of these ordinances was arbitrary, capricious, and unreasonable. Now you're going to have to bear with me, because some of these words I didn't even understand when I read them first. But when we look at how she first started out invalidating, to make something such as a document, contract, or process no longer legally effective. Then we look at arbitrary and capricious. There should be a clear error of judgment and action not based upon consideration of relevant factors, and so is an abuse of discretion or otherwise not in accordance with law, or if it was taken without observance of procedure required by law. Then you take the last phrase she uses, unreasonable, beyond what can be accepted, clearly inappropriate, excessive, harmful in a degree of kind, lacking justification in fact or circumstance. This is what we were laid out by the judge, not by anybody else. Then we look at how she takes care of the rest of this. This matter is hereby remanded to the Village of Ridgewood's governing body for a hearing to establish and recalculate the rates within 120 days. Now, one of the problems I have there is Mr. Wood's report came in November 17, exactly 120 days from when the judge ordered this. But the judge ordered this report to be done 2010 to 2017, not 2010 to 2012. So the report, based on the judge's order, was incomplete and didn't go to the judge's order. You went against the court ruling on this. And it also says in the ruling, to establish and recalculate the rates. The rates were not recalculated by the 120 days. I mean, correct me if I'm wrong, Counselor.
Well, first of all, you're wrong because we're here to talk about ordinance 36.
Well,
And you said that you were not going to rehash the judge's
Okay.
opinion, but that's exactly what you're doing.
oh, Counselor, no, I'm not, because
Secondly, you're also wrong because the initial challenge on this and those first three ordinances that you talked about were for the years that we just spoke of. The first 3 years. So that's what it was about.
well, if you want to look at
The judge's opinion speaks for itself. We're here to talk about ordinance 36.
and in ordinance 36, I'll be happy to hit that. In 36, your first paragraph talks about 14-day trial in the court with Judge Fisher.
Right.
So in your ordinance, you're referencing to this yourselves.
That the ordinance was directed as a matter of the opinion of the court. We don't discuss what the judge decided or anything like that. We just discuss that we were ordered to do this, and that's why it's coming about.
But if you go down in your ordinance on page number 1, you will see that you say 2013 through 2017, and you even admit there that it wasn't done until December 29.
Yeah, and now you've had 6 months to get a report even on the first three.
We're not talking about us right now.
Well, you're not talking about us, but I'm going to talk about you.
Okay.
You've got 6 months, so I don't know what the delay issue is that you're talking about, because both sides have delayed here.
But if that final report was not received here until December 29, we haven't had 6 months.
No, the first report was received by you December 18th. Then the other one was after that. But this issue was already addressed to the court subsequent to the receipt of the reports, and the judge decided not to stay it or find that we were in violation. So if we're talking about 36, let's do that.
I will move on then. What we will do then is go through the ordinance, because if you now take, when you look at what we're facing here, ladies and gentlemen, is you say there is no rate increase, but yet, the judge specifically, and I know you don't want to hear this, Counselor, in her ruling says a refund is to be distributed to the plaintiffs. In yours, it says calculate any refund that may be. So one is contrary to the other.
May I just, I'm just going to step in for a minute. Having sat through all of the hearings, almost all of the hearings at the water during this litigation in Judge Fisher's courtroom, my interpretation was that in the process of adopting an ordinance that the village council then didn't go through the appropriate process, and it was a procedural issue that we didn't have the information that actually is now being provided by Mr. Woods. So what we really want to do is stay focused on the ordinance in front of us. This is a public hearing on the ordinance, and what we need to do is determine whether or not there's an appropriateness to the rates that are going to be established, and we're going to take your public input during this public hearing. If the judge, if there's any issue beyond this public hearing, then that will be something to be determined outside of this moment. So please, because I don't want to interrupt you, we want to give, have a lot of discretion here and allow you to speak, but I really want to make certain that we adhere to the judge's opinion and the way she conducted that hearing, and my interpretation was how we get to the end result, and that we have the appropriate information, again, which has been provided by Mr. Wood. So let's stick to the ordinance and the public hearing.
Mayor, once again, if you want me to read the first paragraph of your ordinance, whereas on July 20, 2017, the Honorable Lisa Perez Fisher, JSC, after 14 days of trial, issued her written opinion, judgment in the litigation in which the court, among other things, remanded this matter back to the village council and directed that village conduct and undertake a rate study to review and establish the appropriate water rates and revenue and expenses requirement for 2010 through 2017 calendar years. Calculate any refund that may be due to the ratepayers as a result of the analysis and setting of such rates and to reestablish the water rates for that time period.
And
that is from your ordinance.
Right, and I heard you say that may be due, not is due, but may be due as a result of the recalculation.
Okay.
So we need to move on and
Now,
discuss.
you're not letting me.
You can speak to it. What we're saying is that we hope you speak to the substance of 3636.
Thank you.
You're not. You want to argue about the opinion, and you're free to go ahead. We're hoping you'd stay to the ordinance, though.
Well, I once again, Counselor, and I understand what you're saying to me, but the judge's words, it's just one little word, a refund is to be distributed.
Now, the judge did not decide after
How
14 days
much?
after 14 days of trial, the judge did not decide that a refund is present or warranted. In fact, the only person who argued that there was a refund at that trial was your expert. And that expert was found not to be competent to render an opinion. So the judge's opinion was basically that if, after the calculations and the review and the rate study being done, the consideration of the revenues and the expenses and what the appropriate rates are, if there's a refund, that's to be calculated as well. And we can differ, Mr. Bronius, we can differ on that.
Yeah, I mean, I'll reiterate one last time. A refund is to be distributed.
If there is one, it will be distributed, yes.
Okay, well, then we can go on with your ordinance as we go through it. Of the recalculations that were put forth here, and I think one of the big sticking points is the 5% that Ridgewood has taken, and that is in your ordinance on, let me find it exactly, must be on page 4, about the middle, whereas in accordance with the court's directive in the litigation, the Woods report contemplates the deferred charge transfer of water utility to the village current fund of 5%. Once again, if we look at, and I know you, and I don't plan on really, I'm just reading what she says. I'm not trying to convince anybody of anything. But when the judge, on her legal opinion on page 94, further, defendant has not established a foundation for an appropriate alternate amount. Recognizing defendant has established a portion of some allocations. Defendant's reliance upon the ability to retroactively take an automatic 5% surplus per year is misplaced. Retroactively taking an automatic or bulk surplus amount is not statutorily permitted. It was not legislatively intended to replace appropriate governance over the water utility by the village governing body. Surplus is permitted to be transferred to the village budget from the water utility budget if in any year a surplus results or can be reasonably anticipated. The surplus can be taken each year only when authorized by the governing body controlling the utility. The defendant has not established precedent to retroactively or automatically, prospectively take 5% surplus in a cumulative fashion for a number of years. The court finds no precedent for such an interpretation. And yet, in establishing 10 to 17, the governing body has taken that.
Well, we haven't done anything yet, but
Well, you
the
are
study is considering it. Yeah.
you are putting it in your ordinance.
It's in the ordinance, yes.
Yes, it is in the ordinance. And once again, the court is saying, not me, the court, that that's not the case.
Well, the court's saying that during the trial, the court opined that that was not established.
Well, I don't know. I think we read things very differently then.
I have a feeling we do, Mr.
Yes, I have a feeling we do. When we go through, when we go through how you've established and taken your 5% over the years, it comes out to quite the amount of money. And I think through reviewing all this stuff, one of the problems we have is information going out there. When we look at your ordinance and put together in 2010, 11, and 12, in 2011, we show a deficit of 9,000. Let me get it right here. It's either 11 or 12. We show a deficit of $9,270. But yet, I look at a press release from the community of December 18, where it quotes your village manager announcement. Furthermore, said the Woods acknowledged a slightly more. Where am I going? You're acknowledging a $400,000 shortfall. Yeah. Said the Woods acknowledged that slightly more revenue that was needed was received by the utility in 2012. That still led to an overall shortfall of $400,000 in the span of 3 years. That did not happen.
Okay, so Mark, I think that we had a 5-minute limit, and we
Mr.
gave you a
Mark
lot
extra
more.
time.
So if you don't mind, unless you have a specific question, and we'll just give a little more, leeway here. Just if you have a question for Mr. Woods on anything in particular. Well, your 5 minutes was up, and that's why I'm just trying to.
Mr. Woods, did you say there was in those 3 years a $400,000 shortfall?
Yes.
Where is that shortfall? Which year?
In 2010 and 2011.
Okay, because in 2010, we show a revenue of $11,642,000. We show a actual expense of $8,850,000. We show a net operating income of $2,792,000. We showed a debt service totaling $2,560,000, and plus produce a surplus of $232,076. So there's no in the red at that point, is there?
What I did in my report for each year,
Is there green light on?
Yes, his microphone.
Okay, just speak into the microphone.
for 2010, 2011, and 2012, I calculated the revenue requirement based on two things. I calculated first based on the budget that was adopted by the village, and then I went back and I recalculated again based on the actual expenses that were recorded for the water utility. I compared both of those numbers to the actual revenues that were generated by the water utility with the rates that were in effect for those years. And when I compare the budgeted revenue requirement to the revenues that were actually collected for those 3 years, on a cumulative basis for the 3 years, there's a $424,000 shortfall.
Well,
If I look at, let me go on. If
We
I
have-
look at the actual expenses over those 3 years and
well,
compare the actual,
that is in their ordinance right
Mark,
now.
could you just, why don't you just let him
Let him finish.
finish, please?
when I compare the actual expenses that were recorded for the utility, again, recalculated using the proper allocation factors, there's a $313,000 surplus for those 3 years. So the revenues that were generated by the rates are actually bracketed by the budget and the actual performance.
The budget that was handed in was a 5% revenue taken out,
Not in 2010.
2011, 2012?
I think it was done in 2011. I'm not sure. I'd have to go back and look at 2012.
Well, because in the ordinance, it specifically states that it was taken out in 2010, 2011, and
Well,
2000.
in recalculating both the budget and the actual expenses, using the proper method, I included the 5% transfer to the general fund in each of those years, both in budget and in actual.
So, that deficit is caused partially by the 5%.
Well, the 5% is part of the revenue requirement. The village is entitled.
Well, that's a matter of interpretation.
Well, it is part of the revenue requirement.
Well, according to the judge, it isn't.
No, that's not what the judge said, at least not what I read in the resolution. And when I look at the statute that exists in New Jersey, and when I look at the Board of Public Utilities practice in respect to municipal systems that they regulate, that 5% is allowed.
Well, I can only tell you what a Superior Court judge said when she says retroactively taking an automatic bulk surplus amount is not statutorily permitted.
And I agree with that. I mean, going back and adjusting the rates retroactively and putting a new rate in effect to capture something that's retroactive is not appropriate. But that's not what the judge's order directed the village to do. The judge directed the village to go back and recalculate the rates that should have been adopted at that point in time. And the 5% transfer to the general fund is part of the revenue requirement that should be included in that calculation.
Now, once again, I respectfully don't agree that's what she was ordering at that given point when I read that, because you can recalculate anything to where you want it to hit. A good accountant can do that. I got 3 brother-in-laws that are accountants, so I know how they recalculate things.
We're not sure how your brothers work. So anyway, your 5 minutes are up and well beyond, so we're going to just go on to the next person.
Okay.
Thank you.
Bob Sansorn.
Oh, so you were yielding to
Oh,
Mark, so why
okay.
don't we just put that here?
And just so the record's clear, I just want to make sure that everybody understands the witnesses, whether it be Mr. Woods or Mr. Calby, have been sworn before, and they remain under oath for their testimony, any testimony they give tonight. Okay, Lorraine? Okay. And Nancy? Okay. Harry Shortway Jr.?
All right, so Harry, you're also deferring to Mark Barnius? Okay, all right.
And Tom Medea? Tom?
Tom Medea? Who's Tom? Is there a Tom in the room? Okay, come on up, Tom. You're up.
Madigan? Yep. All right, yeah.
Oh, you're up, Tom. Did you defer? Can I pass and come back at the end, please? Sure.
Okay. Rudy Boonstra?
Rudy Boonstra here. I don't know what Mark told us, but I'll do it in my 5 minutes.
Okay, Rudy Boonstra okay, yep, got it.
Brian Scanlon?
Brian, where's Brian? Coming up?
Brian Scanlon, Mayor of Wyckoff, 51 Ravine Avenue, Wyckoff, New Jersey. I would like to congratulate you, Mayor, and also you, Deputy Mayor, on your reelection.
Thank you.
It was an interesting campaign to watch, and
It was an interesting campaign to live.
I did want to note one of the optics. Your water rate expert was sitting here last time I was here, and now he's kind of behind the defensive barrier.
So let me just explain, because the last time we
The
were...
optics are very interesting because he's
Yeah.
not really working for the ratepayers. He's clearly working for...
No. So the only reason we asked everyone to sit up here was because otherwise everybody was turning around to speak to the audience, and it was making it difficult for us to hear and understand. So you were having a conversation between Howard and yourself, and so if you feel more comfortable that he's down there, for us, I think it's actually easier that you can kind of interact and everybody has a better visual. But if you're not comfortable, we're happy to send everybody back to the floor.
I also just want,
This wasn't my choice. I was
Yeah.
asked to sit up here
I-
instead of down there.
if I could also say, if he does go down there, they're going to have to sit on this side of the table because of the fact that we can't pick them up for the recording. That's the issue.
Yeah, and so their backs are to us, and it just, this just felt better just to in the communication, from a communication perspective. But if you're not comfortable, whatever you decide, it's your... But- All right, well, we're trying, Tom, so we appreciate, but let's not call out from the audience, okay? Go ahead, Brian, you're up.
Yeah, I don't have a lot to say about the specifics of the water rate study, except that my interpretation of the judge's ruling is that there would be some change in the water rates, but that they kind of miraculously, at least for the period that's been studied, turned out to be fine or perhaps a little bit too low, whatever interpretation you want to put on it. I just find it very strange, and I would really encourage you not to vote on any water rate ordinances until the litigation is completed one way or the other, because it's just going to add to the expense of the litigation, both for the ratepayers in Wyckoff and Midland Park and Glen Rock, as well as the ratepayers in Ridgewood. And I would note the distinction that while the towns outside of Ridgewood have to carry the cost of their water rate expert and the litigation themselves, that you guys can basically finance it all out of the water utility. And I think that's driving up the costs. And the last time I was here, I made a plea that you would consider entering into negotiation, mediation on this so that we could try to resolve something. And it may not be that at the end of the day that I guess your expectation is that we would demand a refund. That may not be what we demand, but what I think is really necessary is that there be a methodology established going forward about what is going to be charged against the water utility, and that everybody agrees that it's a fair allocation of the resources that the Village of Ridgewood supplies to the water utility. And the problem really for me as both a ratepayer and as the mayor of Wyckoff is that you're not really under anyone's control. We don't vote
Brian,
for
can
you
you just hang
guys.
on 1 second? It's very difficult to hear what somebody is saying at the microphone when there's a conversation happening sidebar back here. So if you don't mind, let's just show some respect to Brian Scanlon. Go ahead.
I would just say we don't vote for you. There's no one else controlling the water utility but the village council. And none of the people in Glen Rock, Midland Park, or Wyckoff actually have the opportunity to vote for you guys. And I don't think that's a very fair situation because you're not under the control of any public utility either, any public utility commission, like the BPU, for instance. And I think that the fair way to deal with this dispute is to enter into negotiation. And I would encourage you not to vote on any water rates, whether it's retroactive or future. Leave things as they are. until the litigation is resolved. And like I say, I hope it happens by negotiation. Thank you.
Okay, thank you.
Just in response, Mayor,
Yeah,
I certainly appreciate your comments. We'll take them into consideration, just with the issue of, first of all, the issue of the council acting as a board. As you know, and I'm sure you've looked at it or had council look at it, that's pretty much the way regional utilities work in the state of New Jersey. And the other side is that if we were to not take any action, I think that would, as much as you may think what we're doing is a defiance of the judge's order or opinion, as Mr. Barone has said, that would be a direct defiance of what the judge ordered us to do. And there has been applications for stays, and they haven't been granted. So I think the judge has considered already what she wants done, and that's really for us to proceed. So that's why we're going ahead with this at this time. But
I
certainly
think-
all the rest of it can be taken
I think
into
the way out, though, is for the attorneys for the water utility and the attorneys for the plaintiffs to go to the judge and say, we agree that nothing should happen with the water rates because we'd like to enter into negotiation and we'd like a timeout period. And I think the judge would probably find that a perfectly acceptable thing to do. So
Well,
you
it's
would
something
no
we'll take under
longer
consideration.
feel under sort of the order of the court because one could get her permission to enter into that negotiation.
It's certainly something we'll take under consideration in that regard.
You know, and I just want to say the only reason we were in court was because we did try to settle and we did try to have negotiations, and that was not fruitful. And so that's how it wound up in court. You know, so it's something to take under consideration, but this is where we are today. And this is the public hearing on the findings of Howard Wood and how we're approaching this. And I really encourage you and everyone else to pick his brain and ask him questions and really truly understand how he established the rates that he's providing. I think that's the benefit
And we'll
here.
have an expert do that, someone who is
Appreciate that.
qualified. Having sat on the Wyckoff Council since January 1, 2009, I was there before the litigation started, and I received full reports on the negotiation, which really involved you guys basically saying, we're not changing anything. And
No, you
That
think you
is
got
not true, and I'm going to take...
Well, let's not get into it.
Yeah, I'm going to take exception with that
Yeah.
because it's not true. We really came to good faith negotiations. We came to the table, good faith negotiations, and I would suggest that if you want to share your reports, please feel free to forward them to me because I take umbrage with that statement, but appreciate it. Thank you.
I'm not sure that you were actually on the council when the initial
I was
negotiations-
certainly in the room.
Well, certainly during the mediation sessions, absolutely.
I was there with Judge Doyne.
But in any event,
I was there.
It's not a great way to start off on a mediation session. So if that's what you're interested in, that's not a good first step. But we'll take it under consideration.
Okay, thank you.
Bud O'Hagan.
Bud, where's Bud? Okay, come on up.
Good evening. My name is Patrick Bud O'Hagan, former mayor of Midland Park. And excluding Attorney Rogers, all of you have inherited a big problem here. And I'm addressing just the ordinance as given.
Appreciate that.
I was in there from the beginning when your predecessors refused to sit with Judge Tosco, who was assigned to discuss the litigations and to see where they were going. This point now, you're up to here making a decision farther down the road, not knowing what will happen from the time the litigation began through its justification or adjudication. You're rushing with it. Village of Ridgewood will not be going broke, and neither will the water company. I plead with you, do not vote on this tonight or any other night until the judge that's been assigned to this case hears both sides, water company approach to it, and look at it and see if these numbers are correct. If there's anything in here that absolutely must be purchased, as an example, a gigantic pump or something, I could understand you going ahead and authorizing that. But the whole ordinance, it's improper right now, and you're not going to look good to your own residents, never mind the residents of our other 3 communities. It's something that I think you all should do and figure out what you're trying to do. You have somebody that came up with your numbers. Initially, we had auditors come up with our numbers, and there's questions on it. These numbers here don't have any basis anymore. It's something that needs to be settled ahead of time. And that's all I'm asking you, is to please postpone it, even if it's indefinite. Thank you.
Is there, Nope, there's nobody else.
Mr. Madigan, I think, wanted to speak.
Tom Madigan.
Tom, did you want to come back up?
Can I take 1 minute and then yield the rest of my time to Mr. Timothy Shanley?
Sure.
Okay. I just want to ask one quick question. Thomas
Just
Madigan, Wyckoff,
identify yourself. Thank you.
New Jersey. The attorney's fees for all this litigation, was that paid by the Village of Ridgewood, or was it paid specifically by the Water Department?
I don't know exactly who it was paid for. How about your attorney's fees? Who were they paid for?
Hey, just so you know, I'm standing right here, I can't hear you.
So
Well,
this is a question, the question before us tonight, the public hearing, is on the ordinance, and I really would appreciate it if we would stick to the public hearing on the ordinance. If you have questions to Mr. Woods about his methodology, by all means, please direct your questions. Remember, this is on the record, this is a public hearing about this ordinance, so this will be part of the public record. Please direct your questions exclusively to the ordinance.
Mr. Woods, was your fee paid for by the Village of Ridgewood or from the Village of Ridgewood Water Department?
My fee wasn't part of the consideration of any of the work that I did here in reviewing the past ordinances. I looked at 2010 through 2016, and I wasn't brought on the payroll until last year.
Okay, so, but my question was, and I don't want to use up all my time trying to re-ask the question. So any of your fees or bills, you didn't submit any or none were paid by either the Village of Ridgewood or the Village of Ridgewood Water Department?
My bills are being paid, but I'm not sure where they're charging.
Okay. I'd like to yield to Mr. Shanley, so in the interest of time, because I'm sure you try to cut him off.
Hello, Timothy Shanley, 565 Burritt Place in Wyckoff. I wasn't going to speak tonight, but I felt I needed to just address this one more time. At the first meeting, when the ordinance was introduced, introduction, knowing that there was going to be no public comment at it, I did speak at your general council meeting and did urge you to consider mediating with all 3 of us. Our mayor came up here tonight and did the same thing. I didn't feel that the response I got the first night or the response our mayor just got was that there is any indication that any of you really want to sit down and try to resolve this matter, and I urge you to reconsider. All 3 towns would be willing to sit in a mediation room with you to try to resolve this matter, because as you can see, with the opposition you have here, this isn't going away anytime soon. So I would urge you to strongly reconsider. Thank you.
Thank you.
Anybody else?
Anyone else for the public hearing?
I just, if I may, Mayor, I have a couple of questions that I just wanted to ask Mr. Woods in regard to some of the comments that were made tonight. During your rate study that was undertaken in this regard, did you, during the time period that you were actually doing your calculations and formulating your process, did you ever consider or look back at the allocation rates that were utilized in the original ordinances that were adopted in those separate years?
No, actually, I did not. When I started on this, I asked the village to provide me their detailed line item budgets. There are over 1,000 line items in the budget. They're detailed line item budgets for 2009, 10, 11, and 12, and then also to provide the actual expenses that were recorded for those same years. And I perform my calculations using an industry standard, the American Water Works Association Manual M1, to determine what the revenue requirement was for each of those years. I then also went back and compared the revenue requirement, calculated both on a budget basis and an actual basis, to the actual revenues that were generated with the rates in effect for each year. And it was on that basis that I reached my conclusions. But I never went back and I looked at what the allocations were that were used by the village in the past.
Okay. And the, I know you had done some calculations with regard to in your review, the actual expenses of the village and the revenues. And you made a determination that there was a difference between direct expenses and there were still some that weren't actually kept, that needed to be allocated. But out of the budget, the 100% of the budget, how much of that budget is direct expense?
Well, following the method that's in M1, the first step in any kind of rate study like this is to identify any expenses that are direct allocations of the function that you're looking at. For the water utility, things that would be direct expenses are the power bills that are paid to run the pumps or the chemicals that are purchased to treat the water. I identified all of those expenses, and they amount to about 77% of the budget on average.
Okay.
It varies a little bit, a percentage point or two from year to year, but generally averages out to about 77% of the utilities budget each year. So the rest of that, the other 23%, is what is allocated from the village functions or the shared expenses.
And out of that 23%, a certain amount of that allocation is for water utility employee benefits, right? Pension and health insurance?
Oh, yeah. Out of the 23% of the expenses that are allocated expenses, half of that is pensions and benefits and employee insurance.
Okay. And you were asked last time about the allocation with regard to the water utility office and usage of the village hall. How did you consider that, and how did that play into it? Because it wasn't answered the other night.
Well, in the study, there are 14 separate allocation factors that I developed. And the allocation factor that I used for the village hall expenses is based on the amount of square footage that are occupied by the water utility. There are 2,500 square feet out of about 42,000 square feet in the building. So that works out to just under a 6% allocation. Now, that allocation factor is applied to operating expenses for this facility. And the total dollar amount that's allocated to the water utility as a result of that allocation factor is less than $10,000 a year.
Okay. So that if the water utility wasn't operating here in the space that it has here and operating those administrative offices here, they'd have to go someplace else and find lodging or find a facility that would charge them less than $10,000 a year to make it equal.
Yeah, that's one of the benefits that I see in the shared services arrangement that you have with essentially a department of the village. If the utility were completely independent of the village and it had its own office space, I doubt that they could lease office space for between $8,000 to $10,000 a year, which is what the cost is. Mm-hmm. What's not allocated in any of these factors is the actual cost of this building. You know, the cost of capital to produce the building is not allocated in any way, shape, or form. So that's still an outstanding number that could be calculated, I suppose, and allocated to the water utility, but I didn't do that.
Okay.
I stuck with the operating expenses and the capital expenses that are incurred directly by the water utility.
Mm. And then that's all I have for Mr. Woods. I have a couple questions for Mr. Calby, who answered some questions last week as well. I believe it was Mr. Braunias, I could be mistaken, but brought up an issue with regard to your involvement in the spec writing for the tub grinder. Right? Could you just explain what your involvement was and how that works?
Sure. As my position as Director of Operations for the village, 20% of my time is allocated to the village, not the water utility. And that main function is overseeing the Division of Public Works, Streets and Fleet Division, and Recycling and Sanitation. So tub grinder was part of our yard waste program in Department of Public Works, and I was the one that did prepare the spec and put it out to bid. But that my 20% of my salary, and I believe is even brought up Mr. Woods' report and through the trial, is allocated back to the village.
So you also hold the title of the director of those different departments, is that correct?
Correct.
Okay.
Yes.
And then someone brought up the fact that they had no knowledge of the new fee structure of the 2018 ordinance. That's also a part and under consideration by the village.
Correct.
Was there any point in time where you tried to disseminate the information or at least contact the other participating municipalities with regard to that?
The day after the ordinance introduction, I had sent an email to the administrators of all three towns saying that the ordinance had been introduced, inviting them to contact me to have a meeting to discuss the details of the budget and the ordinance prior to the hearing.
Okay, and did you have any contact or any discussion with anybody with regard to it?
Not until after the last hearing, and we actually, subsequent to that, did have a meeting at all three towns.
All right. I don't have any other questions, Mr. Callen.
Jeff, did you have any questions? Councilman Boyd, Deputy Mayor? Okay, good.
Sure.
Okay.
Well, if we're done with questions, that's fine.
Yeah,
Go ahead.
all right, so why don't you ask your questions first, and then we'll move to close the public hearing, because we used to do that.
Sure, I just wanted to make sure it was clear on the record.
Just to identify yourself, Greg.
Gregory Reed from Sills, Cummins and Gross. We're counsel for the plaintiff class of ratepayers. Just wanted to confirm on the record my understanding from Mr. Rogers that there will be another hearing on June 25th.
Right.
And that's when we will cross-examine Mr. Woods, and we'll also have our expert present on that date.
That meeting's going to start at 7, just so everybody knows.
Our expert's also available, as I've already communicated to you, the entire week of June 18th to 22nd. If you think more time will be needed, we're happy to make him available any of those nights. And as I've told you, we'll have a report on or before June 15th.
We tried to search, I think we tried to search everybody's availability for those other times. 25th was the time that we could work it out of those dates you gave us. So, but thank you.
Okay, and if I may just clarify one point with Mr. Woods to make sure I understand something that you just said. So you didn't look at the allocation percentages at all, say that were in place from 2003 through 2009?
No, the first time that I looked at those was actually after both of the reports were done, and Mr. Calby asked me if I could match up the allocations that I used with the way they do their budget.
So then,
the same category. So both of the reports were done before I looked at how they did their allocations.
so am I correct then that if, say, take health insurance, if they had been allocating 21, 22% for that 6-year period, and then you came in, did your analysis and said, oh, it should be 14, 15%, that difference that was collected, that amounts to millions of dollars, that's not reflected in your report anywhere?
Well, remember that the allocations are only part of the revenue requirement. 77% of the cost of running the water utility are involved with direct expenses.
Fair enough, but again, the 25th, we can get into this in detail, but just want to make sure I'm understanding that correctly. You didn't go back and say, oh, well, they had been allocating 21, 22% for health insurance. They should have been allocating, say, 14, 15%. Therefore, they over-collected $2 or $3 million.
What I did is for each year, let's take 2010, for example. For 2010, I looked at the budget that was adopted by the village and the water utility. And I allocated that budget using industry standard principles to determine what the revenue requirement should have been. I did the same set of calculations for the actual expenses that were recorded on their books. You know, budget and actual aren't always the same, right? So I did the same thing for the actual expenses. Then what I did is I looked at the revenues that were collected with the rates in effect in 2010 and compared the revenues that were collected to both of those numbers. And that's how I determined whether the rates were adequate or not.
Right, you took individual yearly snapshots, right?
Right, that's right.
So if they over-collected millions of dollars leading up to 2009, that wasn't part of your analysis.
And in 2009, let's see, not the last meeting, but the meeting before, a question came up about 2009. I actually went back and I looked to see what 2009 looked like, because, that wasn't one of the years that I was worried about. But in 2009, there was a
Could you just
$2
answer
million
my question? Was it yes or no?
There was a $2 million shortfall in 2009.
Okay.
That's why there was a 21% rate increase. In fact, if I look at that $2 million shortfall against the revenues that they collected, it should have been almost a 22% rate increase. It was too small. They didn't
Okay.
fully recover their revenue requirement that year.
Will you answer my question now?
Ask it again, please.
In your report, you didn't go back and look at, to use the health insurance example I used, hypothetically, if there were $3 million in excess that was collected for health insurance, that's not reflected anywhere in your report.
When did they over-collect health
Between
insurance? by $3
2003
million?
and 2009.
Between when?
2003 and 2009.
Those years were not part of my study.
Okay, thank you.
All right. I move the public hearing on ordinance 3636 be continued to June 25th, 2018 at 7 p.m.
Second.
Seaton,
Yes.
Voight,
Yes.
and Newton.
Yes. I move the clerk read ordinance 3637 by title on fourth reading and the public hearing thereon be open.
Second.
Seaton,
Yes.
Voight,
Yes.
and Newton.
Yes, will the clerk please read the title of ordinance 3637?
An ordinance to amend Chapter 145 of the Code of the Village of Ridgewood fees at Section 145-6, enumeration of fees relating to code chapters.
The hearing on ordinance 3637 was continued to this evening's meeting due to the fact that the village council wanted to allow additional time for the public to ask questions and make comments about the water rate study prepared by Howard Woods. Each speaker will be limited to 5 minutes. The public hearing is now continued. Public hearing now continued. So, come on up.
Timothy Shanley, Township Committee of Wyckoff. I just want to ask that you continue this ordinance with ordinance 3636. And I also want to thank Mr. Calvary for meeting with us a couple weeks ago to explain this ordinance and the meter changes, the meter rate changes. So thank you, and thank you.
Okay, thank you. Anyone else? Public hearing is open. Okay. Move the public hearing on 3637 be continued to June 25th, 7 p.m.
Second.
Seaton,
Yes.
Voight,
Yes.
and Newton.
Yes. Okay. Public comments. We're back to regular public comments, not to exceed 5 minutes per person. So anybody have a public comment in general? Here we go. Welcome back.
Mark Baranias. Now, I just want to clarify something. Yes, it was me that asked about that.
Oh, okay.
But that ordinance specifically said that the specs were developed by the water department. It did not say by Mr. Calby being in charge of 14 other divisions of the village of Ridgewood with the 20% of his time and 80% of the time in the water department. It specifically stated.
That's why we needed to explain it.
Well, that's why I needed to explain, because you sort of said, Mr. Calby sort of said, well, that was part of my job. But it was still
Said water department in the
part of it.
That was mislabeled. But
Definitely
Yeah.
He
did.
did it as part of his job as the other.
As water department.
No, not as the water department, as part
It
of his
was
other
on the wrong
directorship.
letterhead, that's all. It was
That's
on,
why we
he
just cleaned it up.
did it as part of his...
So the resolution was incorrect.
So it's on the resolution is correct, it just was merely on the wrong
The
letterhead. and if-
resolution stated water department engineers were to develop the specs for the tub grinder.
It should have been said village operations. It's 5 divisions I oversee.
So then the ordinance was incorrect.
Correct.
Thank you.
All right, any other public comments? Make motion to adjourn?
So moved.
A second?
Second.
Second, thanks. All in favor?
Aye.
Anyone opposed? Thanks.